Powers to court to summon, examine, recall, and re examine witnesses. Introduction. The primary duty of every criminal code is to discover the truth and ensure that justice is done. For this purpose, the court is not merely a passive observer but is vested with certain powers to secure the attendance of witnesses and obtain all relevant evidence necessary for deciding the case. Sometimes, during an inquiry or trial, the court may find that the evidence already on record is insufficient or that the testimony of a particular person is necessary for arriving at a just decision. In such circumstances, the law empowers the court to summon a new witness, examine a person present in court, or recall and re examine a witness who has already been examined. This power is intended to ensure that no relevant evidence is excluded and that justice is not defeated because of any omission by the prosecution or the defense. Legal provision. The power of the court to summon, examine, recall, and re examine witnesses is contained in Section 349 of the BNSS 2023, corresponding to Section 311 of the CRPC 1973. Object of the provision. The main objectives of Section 349 of the BNSS 2023 are to discover the truth, to ensure a fair trial, to prevent miscarriage of justice, to enable the court to obtain all relevant evidence to ensure that justice is based on complete facts. The provision is based on the principle that the ultimate aim of every trial is the administration of justice and not merely the adjudication of disputes between the prosecution and the accused. Power of the court under Section 349. Section 349 confers very wide powers upon the court at any stage of an inquiry, trial, or other proceedings. Power to summon any person as a witness. The court may summon any person as a witness if it considers that the person's evidence may assist in arriving at a just decision. This power may be exercised even if neither the prosecution nor the defense has requested the court to call such a witness. Power to examine a person present in court. The court may examine any person who happens to be present in court even though such person has not been formally summoned as a witness. This enables the court to obtain relevant evidence that may otherwise remain unavailable. Power to recall a witness. The court may recall any witness who has already been examined if it considers that further examination is necessary. Recall of a witness may be required where certain questions were inadvertently omitted. Clarification is necessary, new facts have emerged, additional evidence has come on record. Power to re examine a witness. The court may also direct the re examination of a witness already examined. The purpose of re examination is generally to explain matters arising during cross examination or to clarify ambiguities in the testimony. Mandatory duty of the court. The first part of Section 349 gives a discretionary power to the court. However, the second part imposes a mandatory duty. The court shall summon, examine, recall, or re examine any person if his evidence appears essential to the just decision of the case. Thus, where the evidence of a person is necessary for reaching the truth, the court has no option but to exercise its power. Scope of the power. The power under Section 349 is extremely wide and may be exercised at any stage of inquiry, at any stage of trial, at any stage of other proceedings before judgment is pronounced. The power may be exercised in favor of either the prosecution or the accused, provided the ultimate objective is to secure justice. Limitation on the power. Although the power is broad, it must be exercised judicially and not arbitrarily. The court must ensure that the power is exercised in the interest of justice. It is not used to fill up deliberate gaps in the prosecution case. It does not cause undue prejudice to either party. It does not unnecessarily prolong the trial. Case law. Mohanlal Shamji Soni versus Union of India 1991. The Supreme Court held that Section 311 of CRPC 1973, now Section 349 of BNSS 2023, confers very wide power upon the court. The court observed that the object of the provision is to enable the court to discover the truth and render a just decision. Rajendra Prasad versus Narcotic Cell 1999. The Supreme Court held that the power to recall witnesses may be exercised whenever it is necessary for the just decision of the case. The court emphasized that procedural rules should not stand in the way of justice. Shahira Habibullah Sheikh versus State of Gujarat 2004. The Supreme Court observed that a fair trial requires that all relevant evidence be brought before the court and that the power under Section 311 is an important safeguard against miscarriage of justice. Importance or significance. The provision is extremely important because it helps the court discover the truth. It prevents failure of justice due to omission of evidence. It strengthens the fairness of criminal proceedings. It ensures that relevant evidence is not excluded. It protects the interests of both the accused and the prosecution. It enables the court to make informed and just decisions. The power reflects the principle that criminal trials are not contests to determine who is more skillful, but proceedings aimed at discovering the truth. Conclusion. The power of the court to summon, examine, recall, and re examine witnesses under Section 349 of the BNSS 2023 is one of the most important judicial powers available during a criminal trial. It enables the court to secure all relevant evidence necessary for a just decision and prevents miscarriage of justice. The provision reinforces the principle that the ultimate objective of every criminal proceeding is the discovery of truth and the administration of justice.